I'm Maurice Crespi. I'll be hosting today's webinar. I'm the managing partner of Schindler's Attorneys. We have with us today on the panel Ian Fleming. He's the CEO of Engaged Business Turnaround. Dean Wright, my partner at Schindler's Attorneys. Peter Gordon of Engaged Business Turnaround. Artisha from IQ Business, and Francois from IQ Business. The idea for today is to have a Q&A format with the panel. It'll either be me asking the panel certain questions, but what we'd prefer is if you were to ask questions by way of the Q&A feature on Zoom. You can ask the questions anonymously. It's important because you're obviously here to understand what rescue is about, but what we can do is address rescue in the context of your specific industry. So please, yesterday we had a lot of questions and it really proved to be fruitful, so please do so. I see we've also been joined by Lisa Marie Hassey, who is also a partner at Schindler's. So on the going through the act and the provisions, provision by provision analysis of the act, when it comes to that, we've already done that, and that video is on the Schindler's Facebook page. It's probably quite boring because it's an analysis as opposed to a discussion as we're going to have today, but please go there for that analysis if you want more of an in-depth discussion. Today we're going to be having more of a practical discussion with reference to the act. So I'll kick off with Peter, just to tell us about business risk in general.
Sorry, Maurice, could you repeat that? You broke up there a second.
Sorry, I said if you could please tell the audience, take the audience through business rescue in general, the concept of business rescue and why it's needed.
Sure. Morning, everybody. Business rescue was inserted in the 2008 Companies Act, promulgated in 2011, essentially to replace a part of the Insolvency Act, which previously allowed companies to go into a form of administration which was not proving very successful in terms of rescuing a business. So business rescue came into being. It very much follows the format of Chapter 11 in the United States, or administration as it exists through most of Europe and Australia. And what it effectively does is puts a steel blanket around the company vis-a-vis any legal actions. So once business rescue is applied for, the company is absolutely protected from any legal action. And that's not only about the recovery of debts, that's any litigation that might be pending against the company. And of course, and then on the day of going into business rescue, it also freezes all the company's liabilities. It doesn't eliminate them, it merely freezes them, whether secured or unsecured. And those are then paid out in terms of a business rescue plan. So essentially what that does is it immediately frees up all the amounts that would have been paid in the next 30 or 60 days to suppliers, creditors, etc., and frees those up to be used in the company whilst it goes through the rescue process. The filing for business rescue is required when the company decides, or when the directors decide, that the company is financially distressed. Simply put, if a company cannot settle its obligations as and when they fall due over the next 6 months, then the company is classed as financially distressed. I think Maurice has made the point in previous webinars that there's probably not many small to medium, if not large companies, think of Edcon, at the moment, that aren't financially distressed and cannot pay their suppliers. So yeah, there's a process, these forms to fill in. The company takes a resolution, the board needs a 51% support. The resolution, together with a sworn affidavit, is filed at Sub-C, and upon filing, i.e. an email has been sent to Sub-C, the company's in rescue. The company then goes, in terms of Chapter 6, into a time-driven process whereby practitioners need to be appointed, creditors need to be advised, business rescue plan needs to be tabled, is voted on by the creditors. Important point, not necessarily the shareholders. The shareholders only have a say in this if their rights are affected. The business rescue practitioner is then in control of the company, and hopefully, and I say hopefully because it's not always the case, certainly is when Ian and I do rescues, is working with the management and the board. Obviously, our preferred route is collaboration rather than acrimonious management of a company. Reece, I mean, that's a summary. I mean, I don't know if guys want to add to that, if I've left anything out.
No, that's great. Thanks, Peter. I think just practically, the hospitality business has been hit hard. So I'd ask that you just take us through an actual example of a rescue that you've dealt with in the hospitality business. Ian, I know you were actively involved in a Mexican one last year. So we have the practical side. What did you do there as practitioners? Ian is a business rescue practitioner. And then what did they do practically from a business, getting the business right point of view? If you can deal with that, Ian.
Sure, Maurice. Well, the practical side of it is a very important part of our service offering. And, you know, one way in which we've differentiated ourselves in the past, and which Cobra differentiates itself as well, is the actual operational side of things, you know, getting our hands dirty in the business and really getting involved in the nuts and bolts. And in the case of the Mexican restaurant operation, I think there were 4 or 5 branches, and you know, sales have been dropping as a result of, you know, various factors. The menu is a little bit tight. The operational costs have been going up. The owner had perhaps taken his finger off the pulse a little bit. The landlords had put up the rent, and, you know, the fixed costs were obviously, you know, still there, and the sales and the gross profit as such were dropping. So we really got stuck into the business. We reinvented the menus. We negotiated with the landlords. This was after we put it into business rescue. And we effected the sort of retrenchments that were necessary. We tried to keep the retrenchments as few as possible. And we moved, we negotiated with staff, reduced their, got them to agree that their salaries and their wages be reduced to a certain extent. And, you know, part of the rescue was also closing down 2 of the restaurants which weren't making, which were really no hopeless. But what we were left at the end of the day was a small, you know, group of restaurants, of 2 restaurants, which were profitable at the end of the day, at the end of the rescue.
Oh, that's the point. What I liked about your approach last year was you went so far as to, as a practitioner, suggest and implement the redesign of the menus, which did lead to a spike in sales. Now,
yes, sorry, Maurice, there's quite a lot of things I left out. You know, it included a massive social media campaign, you know, and it included the addition of a delivery service, for example. You know, and, you know, you'll find there's been a big move away from sitting down and eating towards, you know, deliveries, because kind of people are cocooning themselves in their homes. You know, not only now during the lockdown, but that was actually happening before as well. We moved towards a delivery service and so on, and it was a complete reinvention of the actual operation of the business, and that's a big differentiating factor in what we do.
Now, that was under a poor economic climate that the business had to be salvaged. Now we're dealing with COVID, so it's very, very different. And in the last 2 weeks, I know for a fact that quite a few restaurants are coming through the Cobra ecosystem. What have you done there in relation to those restaurants just in the last 2 to 3 weeks?
So, Maurice, we've been advising them, and we've been putting them into the Cobra ecosystem, and sort of starting to talk to landlords and so on. Restaurants are plagued by the fact that they traditionally have a very high fixed cost structure. So your biggest problem as a restaurant owner during this lockdown period is the fact that you've got a big fixed staff contingent to pay. In other words, a big fixed staff cost, and you've got a big rental cost that needs to be paid. Most of the other costs are variable. So what we are working on, and what part of what the Cobra initiative strives to do, is for companies in the hospitality industry to make a move, or to start really aggressively pushing towards having business models that are variable cost business models as opposed to fixed cost business models. And obviously we can do that as much as possible within the existing framework of the law and so on, when it comes to labor laws and so on. But part of what Cobra will be doing is really aggressively lobbying for changes in the laws which will allow move towards a variable costing model. So for example, how would we push towards a variable costing model in as far as labor goes? We would push to be able to adjust salaries, and this sounds extreme, but this is something we'll be lobbying for in the long run. Adjust salaries to the extent, with the buy-in of employees, obviously, to the extent that turnover fluctuates. How will we deal with landlords? We will be aggressively pushing turnover-based rental agreements with landlords. When I say aggressively pushing, we'll get the buy-in of the landlords. That is the aim of the game. I just want to explain the concept of a variable cost business model versus a fixed cost business model. Those people who are not, who don't quite know what I'm talking about. But if you've got a turnover of say you come out of lockdown and your normal restaurant turnover is 500,000 Rand a month. You come out of lockdown and the first month you only do 100,000 Rand worth of turnover. Now, your normal turnover is 500,000 Rand. Your gross profit is, let's say, 300,000 Rand. And thus you've got 300,000 Rand with which to pay all your costs. Now, your rental is perhaps 150,000 Rand. So that makes up suddenly half your gross profit is gone. Now you come back from lockdown, your turnover is 100,000 Rand, your gross profit is 60,000 Rand for the month, but you've got 150,000 Rand rental to pay. You're going to be making a loss from day one, and it's going to take you months and months to claw back that loss. So what we aim to do is to negotiate as far as possible variable cost agreements, rental agreements with landlords, so that we can pay the landlord according to what our turnover is. So in a month where our turnover is 100,000 Rand, we'll strive to be able to pay the landlord 30,000 Rand in that month.
Can I jump in?
As turnover,
and then I'm going to ask you to continue, because I just think there's some legal principles that apply, which are relevant to what you're telling us. The first legal principle is when it comes to negotiating with a landlord, there are provisions in the Companies Act that allows the business rescue practitioner to suspend those lease agreements. If those lease agreements are not suspended by a business rescue practitioner, the leases remain in force and can be cancelled. If they are cancelled, an eviction is appropriate by the landlord. So it's very important to have the right business rescue practitioner who is clued up when it comes to provisions such as section 129 sub 7, because if the business rescue practitioner doesn't know about it, the business rescue practitioner won't be suspending the lease agreement, which may result in a cancellation. The second legal point that I want to make in relation to what Ian is taking us through is the fact that when it comes to employees in business rescue, the employees' rights remain exactly the same. So if you want to vary their salary, you have to follow the process in terms of section 189. Fortunately, in Cobra, we have very skilled attorneys in HR who can assist on a pro bono basis. That's the idea. But you have to follow the process. You have to give notice to the employees as to why you're doing this. The business rescue practitioner has to try and find a balance between paying employees out on retrenchment and the retrenchment costs, and keeping the employees and seeing what they can do to salvage the business. And I thought it was important to mention that, because now you're in the fix of it, but you're armed with these provisions that obviously assist.
Thanks, Maurice. Yes, obviously we'll be doing as much as we can before business rescue. We have stated as one of the core missions of Cobra that that business rescue is almost a last resort. We want to keep negotiating within the Cobra ecosystem and gain as much advantage as we can for our clients within that ecosystem, and find a balance between debtors and creditors within that ecosystem.
Yeah, can I stop you there? Sorry, let me stop you there. Again, opportunity that I jump in because I'll show how it actually works mechanically with the notice that we've drafted. And the idea is that you avoid a business rescue by coming into the ecosystem. This notice that I'm sharing on the screen, you put on your letterhead. It says we've joined the Cobra ecosystem. The Cobra War Room is a pro bono service to businesses that need urgent assistance. It's a partnership between, and we set that out. Due to our business's financial distress caused by COVID, we're obliged to consider putting our company into business rescue in terms of Section 129 of the Companies Act. It's a fact. You're obliged to put it to the vote. And if you decide not to, you have to write to your creditors and employees and say, we decided not to, and for the following reasons. And here's the reason. You're in Cobra. In Cobra, this letter goes to your creditors and you say, please join the Cobra ecosystem that will assist you. We will assist you in mediating a financial arrangement between you and the company within the ecosystem so as to ensure our continued survival. The idea is that attempt to strike a balance between the creditor and debtor relationship so that everybody keeps their heads above water regard being had to each business's cash flow. So it's important that the system that's being employed is very different to what you'd be doing, what you were doing last year. This now is more of let's keep the businesses out of business rescue. We want to avoid it. There is a means to do that, and that is through the negotiation that you're speaking of. Sorry, once again, I interrupted Ian, but
no problem. Yes, so we'll be able to achieve a lot within the Cobra ecosystem, and merely for a company, a restaurant, or a company in the hospitality industry, or any company for that matter, just to be in the ecosystem will give us a huge amount of leverage and sway when it comes to negotiating with landlords and finding win-win solutions. That's what we're going to have to do during this crisis, is to find win-win solutions, as far as possible, within this economy that we're effectively building within an economy, to use a phrase that Maurice used yesterday. So yes, when it comes to business rescue, should it be necessary, we'll put the companies into business rescue. Should there be a creditor who's really pushing hard for a liquidation or an eviction or legal action or whatever the case may be, we then do have the option to put the company into business rescue. And once it is in business rescue, still within the Cobra ecosystem, that really gives, then landlords really tend to come to the bargaining table and find, negotiate. Firstly, they're negotiating now with an independent business rescue practitioner, as opposed to the tenant with whom the relationship may have soured. And that really brings them to the table and allows us to negotiate win-win solutions with them. Thanks, Maurice.
Brilliant. Okay, so Peter, we've given an idea around the negotiations and stuff. Can you tell us how that then translates into a plan?
Maurice here, with pleasure. I'm also going to just ask you if I can just give some practical examples of the hospitality industry in particular, but let me cover your point first.
Yeah.
The terms of the Companies Act says that the business rescue practitioner is obligated to, together with management, put together a business rescue plan. Now that, in broad terms, is not vastly different from what a normal company business plan would look like when you're doing your strategy and you're doing forecasting forward, etc. And really what the plan's got to cover is a bit of obviously the background of the company, the level of creditors, the details of the assets, etc. So fairly in-depth analysis of what the balance sheet and profit and loss look like of the business, who owns it, a bit of a story of why the company's in rescue and why it was in financial distress. And that's important because obviously a creditor who's going to vote on this plan has got to understand how those hurdles have been overcome. I mean, Ian used the example of, you've got a restaurant chain with 10 outlets and 5 of them are not making profit. Well, the plan is to close those down and, reestablish the profit on the remaining 5, etc. So very practical business type issues in the plan. The plan then has the proposal, which is what the business rescue practitioner plans to do. I've just covered it, close down restaurants, close down business, sell off the business, etc. And then it would normally include, it's not required within the Companies Act, but we'd always include what we consider to be what is termed in the Act the substantial completion of the plan. And that really is quite important so that creditors know, is this going to last for another 10 years or is this going to be through in 3 months? We do have a principle, Ian and myself, to try and get businesses out of rescue as quickly as possible. And even in a situation where the full plan hasn't been implemented, because the word substantial is in there, we will put plans in place, protections in place, so that everybody is paid out over the period of time under whatever conditions we put in the plan, and that it's secure so that we're not handing a company back, which then defaults yet again. The important thing of coming out of rescue is when we hand the company back, and this is a normal business rescue process, the company must be financially viable. So the balance sheet should be technically solvent. That's the assets of the company fairly valued, should exceed the liabilities of the company fairly valued, as well as the company is able to pay its way forward in the next 12 months. Now this, we're falling back into the Chapter 4 of the Companies Act, which has a requirement of the financial ability to pay your debts as and when they fall due over 12 months, as opposed to 6 months, which is included in Chapter 6 vis-a-vis company business rescue. So, and that plan is then presented, the time limits, it's got to be presented within 30 days of going into rescue. Very often we apply for an extension. We prefer not to, but very often, because this can be fairly complicated, you have to apply for an extension to file the plan at a later date. That requires 50% plus one of the creditors, or what we call the affected parties. And so you now finished your plan, you publish it, 10 days of publishing it, you've got to call for a vote, Section 152 vote. And in that voting process, the practitioner presents the plan, explains the process and what the plan entails to the assembled gathering, which are the accreditors essentially, who then, once they've heard the impact of the plan, and remember the plan might include a compromise with creditors, so we're planning to only pay you all 20 cents in the rand or whatever it is. Important point here is that every step of the way the practitioner is trying to beat the liquidation valuation. So the point at which the practitioner believes that he can no longer beat a valuation, a liquidation valuation, which I have to say is a fairly low bar, because liquidation prices are normally rock bottom prices in the wind up of a company. As long as you can beat that, you've got to state so in your plan and every communication with the creditors. Essentially, you've got to tell them that you think you can do better. And if that is the case, then you've put the plan forward and then the creditors vote on it. The voting rights are by rand value, and it's everybody in attendance, person or by proxy, at the meeting. In order to get the plan through, you've got to have 75% of the voters, by value, as I say, vote positively for the plan. And of the voting group, at least 50% has got to be independent. Independence is classed as people that have essentially got no connection, prior connection to the company, other than as an arm's length supplier. So a shareholder who's put money into the company, a director who's put money into the company, a fellow subsidiary of a group of companies that's put money in is not classed as independent. So they're excluded from that calculation. So summary, 75% have got to say yes. And of those voting, so you've had 100 rand voting, 75% of that 100's got to say yes, and 50% of the 100 has got to say yes as well. So obviously that would be 50 rand. So yeah, once it's approved, it becomes an adopted plan.
I'll stop you there. So just practically, I'm going to put up an example on the screen for you. Can you tell us what would happen with the vote here in this scenario?
The shareholder loan is 50, the creditors are 50, so assuming...
No, 100. The shareholder's loan is 100.
Sorry,
creditors
beg
are 50.
your pardon. Yeah. I must have had a late night last night, Maurice. So your total affected people in this example is 150 rand. Now you have a vote, and I'm assuming that all these people are in attendance, as I say, person or proxy. So when they vote, now it becomes interesting, you've got to have 75% of those voting saying yes. So 75% of 150. So you calculate that, and then you work out, and it's an interesting question you're posing here, Maurice, because often you work out that the shareholders have got to restrict their vote, which are obviously allowed to do. So if all those creditors are voting yes, the 50 rands worth, the maximum that you can then have of the non-independents voting would be 25. So only 25 of the shareholders alone should then vote, assuming that they're all going to say yes. Does that make sense?
Yeah, no, it does. Yeah, thank you. Thanks for that.
Yeah. So, I mean, it is an interesting point. You say to the creditors, guys, you've got to vote. You say to the shareholders, rather. Remember, the shareholders, if they are supportive of the plan, which hopefully they are, it means you work with them. If they're supportive of the plan, you've got to go to them and say, listen, guys, I only want you to vote for 25%, or if you're giving me a proxy, please only give me a proxy for 25% of your total amount owed.
Okay, so what I've done here is I also want you to deal with the fact that the shareholders, 100%, the security holders say yes, as do the two directors say yes. Shareholders alone say yes, but the creditors of 50 Rand say no on the voting of the plan.
Plan fails.
You walk us through that?
So when a plan fails, what happens is you've taken the vote and you don't have the independent vote because these shareholders are not. Now remember, the directors, whether they say yes or no is irrelevant because they're not, I'm assuming they're not owed money by the company.
That's the point I wanted you to make, and then the shareholders.
So the shareholders, the shareholding 100% say yes. Irrelevant if I haven't affected their rights. So now I've got a shareholder and he's got an ordinary share, let's say. And I say to them, look, I'm going to change your shares into preference shares. They've now had their rights affected and they have to vote on the plan in a separate vote. So the creditors would vote first, and then we talk about having a vote on a preliminary plan. And we then take it to the shareholders to vote, and the shareholders vote as well. And in the shareholder group, I need 51% to say yes. So now the shareholders in my normal voting on the plan, where I'm presented to the creditors, I'm not interested in what they think as shareholders. As shareholder loans, I'm very interested because they've now changed their identity from being an equity shareholder to being a creditor because they've lent money to the business. However, they fail the independence rules, so they're now classed as dependent or non-independent rather. So I need to now get the creditors to vote, and if they say no, and I'm assuming that all the creditors are independent in your example, Maurice. If the creditors vote no en masse, I've failed. I need 75% of those creditors, i.e. 37.5 Rand, has got to say yes to my plan in order to get it through.
We have a situation as a business rescue practitioner where the creditors have said no, the plan's not going through, but you know for a fact and you have evidence that the creditors are acting in bad faith. The plan is absolutely brilliant. It would save the company, it would save the employees, but now the creditors are voting no. Is there any recourse?
Maurice, yes, and as daft as your example sounds, this is a very real problem. Because in that creditor group, I've got a acrimonious guy. He was about to take, he might be the previous owner of this business. It might in fact be the bank, might be one of the secured creditors who thinks, why should I go with this plan if I exercise my security I know was oversecured, I'm going to get paid out in full, I'm going to vote no, with the hope that the company is going to go into liquidation. And surely I, as the secured creditor, would do better in liquidation. So now what the practitioner can do, he's got a number of options available to him. If he believes, as in Maurice's example, that really, guys, any court would believe that this is a really sensible solution and this is in the best interests of all these creditors, shareholders, directors, and remember, employees, all the stakeholders, the suppliers, etc., he can go to court and he can have this vote set aside. Obviously, we're looking at an extreme example, so I've got 100% of creditors saying no. That would be a difficult one to argue through the courts. But where you've got a situation, you manage to get 70% of the vote, and you know that extra 5% you needed was the 30% creditor who voted no. You can go to court and say, look, 70% support my view that this is a viable business rescue plan. So courts, please can you rule that this vote should be set aside as inappropriate. If you win, then obviously the plan goes through. Obviously, that's an expensive exercise, and let's remind ourselves that in rescue, normally cash is very short, and one tries as your hardest to avoid any form of legal action and going to court. But if that is necessary, then believe me, we will do it. The other option the practitioner has is he's now sitting in the meeting, facing these creditors have all said no. He then says, okay, guys, I tell you what, I'm going to try harder. I hear what you've said. I've taken the feedback, because remember, this is a two-way meeting you've had, so you get some feedback from the creditors. It would be sad if you get to this position, because clearly you should lobby creditors beforehand to make sure, you know, never go into a political vote if you don't know the answer beforehand. Same thing in a rescue. Try and lobby the creditors to make sure at least you've got that 75% vote in the pocket. So you now facing a situation where one of the creditors is put up, which might well be a very reasonable argument. Also be careful here, because creditors often are on the fringes waiting for this business to go into liquidation, because they might well think that this is an opportunity for them to acquire the trade of the business at rock bottom prices. So you often, creditors are not wearing only one hat as somebody that's owed money, but rather somebody that's got desires of acquiring whatever it is, the intellectual property, the machinery, the plant equipment, the people, etc., etc. So that's, you've got to be very cautious of that, and you've got to read the underlying theme of where creditors are at the time. So now you've got a bunch of creditors, and you say to them, right, I'm going to try harder. I'm going to put an amendment to the plan. You go away, you insert it in the plan, you recall the same meeting in 10 days' time. The same process. You go through the same process again, and lo and behold, 50%, 50 Rand says no. Back to square one. Now what you can do is you say, right, I'm presenting it to the creditors. Have you got any suggestions? So you get some wise guy who says, I'll tell you what, let's put it into liquidation, and you're aware that all he's after is the assets. You can refuse as practitioner to put that in the plan. So the practitioner, any suggestion by a creditor as to an amendment to the plan or a completely new plan, if that's the case, you can refuse to accept it if you believe there's no chance in hell of this thing going through. And if that is the scenario, then obviously we're into fairly heavy lobbying and negotiation with the shareholders. Bearing in mind that any step of this process, one can go to court and say it's inappropriate. You could have a situation, and in Maurice's example, where, you know, the creditors, it might only be one creditor, is really desirous. I've got one at the moment, I'm on the other side of it, advising one of the creditors, where there's a bunch of creditors who are desperate to get hold of this business, and it's a fairly wealthy business. And the shareholders are fighting this because they know that they could do better with the practitioner, do better in paying everybody off. So it's become, this thing has been going on for 3 years. I can't think how many times it's been through the courts to rule on inappropriate votes, to rule on inappropriate actions in the business rescue. So, and that's a horrendous position to be in, because that's money just being wasted that should be paid to the creditors. But these things do happen in a practical sense. If all else fails and the practitioner can't get his plan through, the creditors don't come up with an alternative, the shareholders cannot put in further money to change the rescue plan, the practitioner then is obligated to put the company into liquidation because you've got a failed plan. The Act is reasonably silent on this, but the implication is if a plan fails, it should be a situation where the company or the practitioner then puts the company into liquidation. The other thing to just point out with the business rescue plan is that it doesn't necessarily only have to be a situation of rescuing the business to hand it back to the shareholders to trade on into the future. The business rescue practitioner can, with the consent of the creditors through the plan, and Ian and I have just finished exactly a case like this, where we agreed that we would sell off the assets. The company wasn't able to continue trading. They'd shown an inability to do this particular, it's in the fiber industry. They were good at getting fiber into the ground, but not good at getting it into the ground at the right price. They'd made significant losses, and we agreed with the creditors to do a controlled wind down, whereby we took tenders on an open tender basis for the assets in the company. Delightfully, we had at least two, in most of the assets, two bidders for the assets, which allowed us to get top price for these assets. Difficult assets to sell because it's a very restricted market. And we managed to sell the assets, in fact, to one of their biggest suppliers, partly, and then a competitor bought the assets, the remainder assets. And going through that process, we managed to get a far better value for the assets than we would have got under liquidation. This type of asset, you put it under the sheriff's hammer, you believe me, you're not going to get very much for it at all. So all we did, as I said earlier, we beat the liquidation price and managed to pay the creditors, albeit quite a low dividend. They managed to get at least 5 times they would have got in a liquidation scenario.
Great, thanks, Peter. Just to mention the application that you made mention of, the High Court application, generally costs between 20, 30, 50,000 rands. Because it's a High Court application, you have to go to lawyers and you have to get advocates to move it. What Cobra has done is we've arranged through Schindler's attorneys to launch that application on a pro bono basis, so long as you've come into the ecosystem from the beginning. So if we cannot come right and we cannot save your business, then the application, which we'll do everything to avoid, will come at no cost to you. I've got a question by Kim, which I'd like to answer. The impact of business rescue on employees is high. How do you successfully manage the impact of change on employees, communicate, collaborate, and even co-create where possible, all levels of employees? So what we've done, Ian mentioned that it's important to get the salaries to a variable position as opposed to a fixed position. What we found is that employees have been very, very receptive to the following proposition. The directors, or every single level of management, you agree on a salary reduction at a director's level. So the directors say, we'll take a knock on salary, but then what you do is you take those salaries and you put it into, as it would be, so what employees have agreed via a process and via going through Section 189 and going through the legal process is whatever money comes in will be distributed pro rata to the employees, pro rata your salary. So if sufficient money comes in, well, then everybody gets paid. If insufficient money comes in, then there's a knock on salary, so it makes it variable, and the shortfall will eventually get paid when salaries are, when cash flow permits. And if you want to, you can create, let's say, a reserve fund for the employees for life and death expenses. And that's in fact something that's been implemented in a company that we're involved in, where there is this fund for life and death expenses for the family. So they need to pay school fees and they're not getting the salary. Well, the company has put that in place. But that takes me to a very important point. And that is, if you're going to do that, if you're going to put money into your business, that is a financing of the business, and there's important implications when it comes to that. But when it comes to the employees, one needs to impress on them is that rather have a business post-COVID that they can work for than no business at all. There's no point in sucking blood from stone. And insofar as Cobra's assistance is concerned, we are prepared to speak to the employees. We can have private Zoom meetings with the employees to explain all of this and to explain that there's always be an evil what they need to do is pick the lesser of those evils. Yeah, I think I've dealt with that. So just moving into the situation where I said that in the one business, this fund was created. Ian, if you're going to create a fund and you're going to put money into the business as a shareholder, can you comment on that?
Yes, certainly, Maurice. It is better, like you said, if business rescue, if the company's likely to go into business rescue, it is better to put money into the business once it is in business rescue, because that allows the repayment of your loan to rank above creditors. If you're putting in if you're a shareholder and you're putting in your loan into the company in order to pay salaries or whatever the case may be, prior to going into business rescue, then you rank right down below amongst the concurrent creditors. If you put it into the company once the company's in business rescue, then it qualifies as post-commencement finance, which means while it is in business rescue, the finance that you've put in will be repaid straight after the business rescue practitioner's fees and disbursements are repaid. So while it's in business rescue, the business rescue practitioner's fees and disbursements rank right at the top in terms of repayment. In other words, they get repaid first. And as a post-commencement finance creditor, you will be able to get paid second. Should the company eventually go into liquidation, if you're a secured post-commencement finance creditor, then the repayment of your loan in a liquidation scenario ranks right at the top, even above business rescue practitioner's fees, because in liquidation, the business rescue practitioner's fees drop right to the bottom and rank as part of the residual or alongside concurrent creditors. So if you're going to put money into the business, A, put it into business rescue, and B, secure it, if possible, via an asset in the business.
Thanks for that. And whilst I've got you, when directors see that a business is failing and it's going pear-shaped, they are reluctant to put it into liquidation and they're reluctant to put it into business rescue because all of a sudden they lose control. On the question of control and on the question of directors and their involvement in business rescue, can you just deal with that? What happens now, apropos the directors?
Absolutely. The directors still have their fiduciary responsibilities. They remain in place. But ultimately, the directors report to the business rescue practitioner. Now, this is why the choice of the business rescue practitioner is so critical. And most experts will tell you that the success or failure of a business rescue is 99% determined by the choice of the business rescue practitioner. You need somebody who is with business acumen, you need someone with EQ, you need somebody who has the full set of skills to be able to do business rescue and turn around properly. You need somebody who's not going to come along and kick the CEO out of his seat and think that he knows how to run this business. Because like we always say, when we walk into a business, we will never know as much as the CEO and his board know about the intricacies of the business that he's built up over the last 10 or 15 years or however long. We will never have the relationships that he has with clients. We'll never have the relationships that he has with suppliers and with his customer base in general. So business rescue practitioner, and this is a mistake that a lot of business rescue practitioners make. They come in there and they just sort of take control and it's their way or the highway. And unfortunately, since the advent of business rescue in 2011, when the first business rescues started, business rescue practitioners have not done themselves any favor, and they haven't done the business rescue industry any favor through the way that they've carried on. So yes, rest assured that everybody, all the business rescue practitioners within the Cobra ecosystem have impeccable credentials, have impeccable track records, and really know how to run a business rescue. We are there to work with the directors of the company. We are there to hold their hands through the process. And we are there from an operational perspective and from a multi-skilled perspective to be able to close the gaps where the company might be lacking in skills and for that reason has gone into business rescue or has gone into financial distress. So just to repeat, choice of business rescue practitioner is absolutely everything. Yeah, thanks, Maurice.
Yeah, you want a business rescue practitioner who who isn't only interested in, the problem is that a business rescue practitioner, if he or she is only motivated by fees and doesn't care about the business, that the context allows for that, unfortunately, because they get their fees regardless and the fees are super preferent. But having said that, if a business rescue practitioner has misconducted him or herself, one does have relief. One can go to court and have the business rescue practitioner removed and substituted.
Absolutely. Can I just say something there, Maurice? That is very true, and that is a remedy that you've got as an affected person. You can go to court to have the business rescue practitioner removed, but nobody needs that. You know, nobody needs the pain of having a business that's distressed. You know, and trying to save it. I'm talking as a director of the company or as any affected person of the company. You don't need the stress of having having a distressed business that you're trying to fix, and B, now having to remove a business rescue practitioner, which could take years in court, and find another business rescue practitioner to replace them. Hence the reason why it's so important to get the right business rescue practitioner right from the start.
Sure.
Sorry.
A question that pops up quite often, Peter, and I think it is an anxiety with quite a few of the businesses that we've seen over the last two weeks, and as a general anxiety, is the fact that the directors or shareholders, particularly small businesses, have signed surety, and business rescue gives a moratorium to a company in relation to legal claims, but what position does a surety find him or herself in?
Maurice, a very important point, especially in the small to medium companies where this is very often the case. It's a question we always ask in the first meeting with the company. If a surety exists, it very much depends on the wording of the surety. It's normally a surety to the bank. Classically, I would say 80% of these are bank driven. And the important thing is to let the practitioner see that fairly early on. So for him to decide either on his own or with legal support as to what the liability is of the individual. Very often sureties include a clause that states that the surety holder can take action against the company and independently against the individual. You know, one would try and argue that if your surety has been settled, or rather if the security holder's liability has been settled through the business rescue process, that they should then not take action against the individual who signed the suretyship. And it's not always the case, because if you're doing a business rescue plan that says we're going to pay out over the next 5 years, a creditor holding surety might go after the individual as well. So it does call for a lot of negotiation with the person holding that suretyship, but it does expose director, shareholder, or whichever the individual is that has signed the suretyship. An important practical issue is here, as I've dealt with this, a company gets sold, and the seller, who's the director and shareholder at the time, sells it and is retired on the coast watching the waves, and he suddenly finds that the surety that he signed is still in existence and was never replaced. The company goes into difficulty and suddenly he's called upon to pay his surety. So the advice generally, not only in business rescue, is do be cautious. Firstly, with signing suretyships, and once you have, make sure that you've got a file somewhere. Hopefully it's an empty file, but there's a file somewhere that you've got a record of what suretyships you signed. So if ever there's difficulty, or if ever you sell the company, you know what needs to be cancelled as a condition of the sale of the company.
Yeah, no, I think it's important to mention there. I hadn't thought of it before, but I dealt with a matter outside of business rescue where we defended a claim on behalf of a surety on the basis that the principal debtor had entered into a compromise and agreed on a settlement of the claim. And what we successfully argued is that the compromise, the principal debt was settled on the basis of an actual amount which was in discharge of the principal debt. Therefore, you couldn't look to the surety, which worked, and that is the law. So I'd imagine if a creditor votes in favor of the plan, that compromise, I don't know if you've dealt with this, would in fact release the surety from the balance of the debt. Have you dealt with that? Have any of you guys had that?
I think that comes down to the wording again of the surety, Maurice. You know, the section 154 says that if a creditor exceeds to the discharge of a debt, then he can't go after the company again afterwards. But that doesn't preclude him from going after the surety if the surety allows for it. There has been a legal precedent whereby, and it was a fairly simple surety agreement that had been signed, and the court found that the company was in business rescue and the director had signed a personal surety. It was a fairly simple surety. And the court found that the business rescue process had to run its course whereafter the creditor could then go after the director in his personal capacity. And the reason that the court gave for that was the fact that the quantity of the surety debt would not be able to be quantified until the business rescue had run its course, because whatever the creditor received during the business rescue would obviously reduce the debt accordingly. So yes, so that is the business rescue process. In a lot of cases, does actually delay the ability for the creditor to enforce the surety, to act against the surety.
But Ian, just in addition to that, Maurice, we are dealing with one right at the moment. A company sets up not a subsidiary, they lend money into a fellow company, the same shareholders. It signs suretyship. The company that formed the new trading business signs a suretyship to its major supplier, binding the original company. So let's call it company A, sets up company B. A signs surety in favor of company B. Company B goes into rescue. The shareholders of A are deeply concerned because private assets, including houses, are in company A. And if and that's the only asset. And if the surety is called upon, they're going to have to sell their private residence to pay out this supplier. We took legal advice on this, and what we did in the business rescue plan is we negotiated, well, first of all, as Ian rightly said, the wording of the suretyship said that the secured creditor could go after either party, irrespective. In other words, we've got a business rescue plan. The compromise is that creditors are going to be paid 30 cents in the rand. We wanted to satisfy the security holder in order to protect the overall. If we lost the shareholders in A, we would lose the business because they are instrumental in running B. And what we managed to do is with a fairly large group loan between these two companies, we ceded the portion of their contribution in the compromise to the secured creditor, thereby paying out the secured creditor in full, albeit over time. So it was still a negotiation. The time period is 18 months that creditor should get paid. But because it's only 30 cents in the rand, we topped up the 70 cents for the secured creditor to make sure that they were satisfied. The negotiation is ongoing, but it looks though the creditor is going to accept our plan and get paid out over a period of time, and in writing agreeing not to pursue the company A, subject to being paid out in full, obviously. So it does call for a bit of interesting negotiation to make sure you can achieve that.
Thanks, Peter. We're almost done for the day. I'd again call for questions by the attendees. Whilst we wait for those questions, if there are any, what I'd like to do is go through certain aspects of business rescue that haven't been dealt with, and they arise from questions that have been asked previously. So the first is, does business rescue apply to closed corporations? Answer to that is yes, it does. You cannot form a closed corporation these days, but there's still closed corporations that are around under the old act. Another question that has arisen is prescription. As you know, you have 3 years to sue somebody, otherwise the debt prescribes, and that's a complete defense. If somebody sues you after 3 days of a debt becoming due and payable, your defense is sorry, it's prescribed. During business rescue, prescription's interrupted, it's suspended. So business rescue, if the company is in business rescue for a month, prescription would then be 3 years and that month. a question that arose yesterday that I thought was quite important was whether a trust would be regarded as independent if the shareholder ultimately is behind the trust. And we went through the act there, and the question is whether the shareholder has control. If the shareholder does have control, the shareholder will not be regarded as independent for the purposes of the vote. And lastly, I just want to conclude, I think it was touched on by Ian, a benefit that's been identified only yesterday in relation to Cobra is the fact that every business that comes within Cobra has a business that there's the potential for that business to supply other businesses within the ecosystem. So what's nice about Cobra is we're identifying synergies between Cobra companies, businesses, where they can actually work together and actually procure business for one another, which is a benefit that we hadn't anticipated, but is obviously very, very useful. I see there is another question. When is the deadline to enter the Cobra ecosystem, and what are the qualifying requirements? So there is no deadline, but having said that, it's a pro bono initiative, and you'll recall that I said right at the end, if business rescue fails, the High Court application to convert the business rescue into liquidation is handled on a pro bono basis. So the only question of timing is you need to enter the ecosystem in the beginning so we can try and salvage that business so that we do not, we don't have to launch that application. If you come right at the end when you've tried to do it and it's failed and you ask us to launch the application, well, we never had control of the process, so we'd be reluctant to do that. Though, let me say this to you, chances are we'd still agree. And what are the qualifying requirements for entry? Everybody has the ability to enter. Everybody must enter, in fact. The question arises, what qualifies for pro bono? And when it comes to pro bono, one has a means test. When it comes to individuals, and the means test when it comes to individuals is, do you earn less than 7,000? What Cobra has done is the means test is basically if any fees by any of the partners come between a successful business rescue and a liquidation, well, those fees do not get charged. So the means test is inherently built in with that principle that there will be no charges if a business will be rescued as a result of there being no charges. So that's the pro bono. So what we're finding is 95% of businesses are in that position. They need the help. They can't afford the fees. There's no money for the fees, and that's where we come in. Where there will be fees is if you don't pass the means test, because it's not pro bono by definition. And that is where you're in a situation where, let's say, you're sitting with a lot of cash, and all you need is a reprieve of 3 to 6 months, but at the end of the day, you'll have the cash, and the Cobra partners came in and they saved the day. In those circumstances, because you don't qualify by the Law Society means test, the fees would be charged. Fees will also be reduced to make sure that a business rescue succeeds if a write-off is not necessary. I see that there's 6 questions in the Q&A. Oh, I'm sorry, I missed those. I'm sorry. Morning, everyone. I hope this message finds you well. Thank you again for putting this together. Really impressive. Thank you. We are not yet in a position requiring business rescue, although future unknown at this point, but would like to find out and plan ahead. I'd imagine sending the Cobra letter now rather than later is a practice move. Absolutely. So we don't, all businesses we want to keep out of rescue, but the way to do that, the way to avoid a vote to place your business into business rescue is to go into the Cobra environment. Bear in mind, the Cobra ecosystem is just, you have somebody to call. It's phone a friend. If you need something done, you have over 1,000 consultants that you can tap into for that advice. So it's not as though you enter into the ecosystem and there's a formal process. You enter into the ecosystem and we advise. And obviously you can exit the ecosystem at any point if for whatever reason you consider it to be undesirable. So the most practical move at the moment is for you to be able to say, yes, I'm in the ecosystem, and we get that letter out and we start speaking to your creditors. Next question by Jane. I assume a director owed money by the company is regarded differently. No, a director that's owed money, interesting question. A director can be owed money in the capacity of a shareholder, but then that's a shareholder loan. A director can be owed money in his or her capacity as an employee. And in that case, they're treated as an employee. And then a director can be owed money for, let's say, his or her role as a non-executive director, not as an employee. And in that case, the director would merely be a creditor. So there are various capacities that a director can lay claim to monies in the company, and the claims will be treated differently. By way of example, the claim as employee ranks differently to other claims. So yeah, good question. What does business rescue cost? If you don't qualify for pro bono, and there are fees associated with it, it's on a tariff basis depending on the size of your business. So you have various categories of business rescue practitioners. On tariff, I'll ask Ian to jump in with the rate, but what one can also do is negotiate with the business rescue practitioner on a contingency basis. So unless your business is successful or succeeds post-business rescue, you don't pay a cent. And if you're going to find business rescue practitioners outside of the Cobra environment, please find those that are going to do it at least at risk. See, the director is the owner and is the income generator. So on that score, yes, the director is the owner, is the income generator. What capacity is the director generating the income? Non-exec capacity is different to an employee capacity. How do I enter the ecosystem? It's very simple. You send an email to info@cobra.org.za. It enters a logging system. You get a reference number. A consultant will be appointed to you. What happens is 3 consultants actually are appointed to you. One is legal, one is business rescue, and one is the IQ consultant. That is overall strategy. So all you have to do is send an email, and the rest will be handled for you. Are there any comments by the panel, just to conclude? Okay, great. Thanks, everyone. This was fantastic. Love the questions. You can join us tomorrow. If you are in the hospitality business, there is a large panel discussion on Tuesday that you can register for. We've got economists who we're going to be speaking to. We're going to be speaking to business rescue practitioners who own restaurants themselves. We're going to have advocates who specialize in business rescue. So it'll be quite an exciting discussion. And if you are in the hospitality business, I ask that you prepare your questions in advance because you've got some serious experts who will be answering them. Thank you, Manny. It's only a pleasure. As I said, you can join us anytime, but send us an email and let us take care of your business. That's what we're here for. Great. Thanks, everyone.